United States Department of Justice, Office of Special Counsel, John H. Durham. May 12, 2023. To Attorney General Merrick B. Garland from John H. Durham, Special Counsel. Subject: Report on matters related to intelligence activities and investigations arising out of the 2016 presidential campaigns. The attached report is submitted to the Attorney General pursuant to 28 C.F.R. 600.8c, which states that, at conclusion of the Special Counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions reached by the Special Counsel. In addition to the confidential report required by Section 600.8c, the Attorney General has directed that the Special Counsel, to the maximum extent possible and consistent with the law and the policies and practices of the Department of Justice, shall submit to the Attorney General a final report in a form that will permit public dissemination. This two-part report, unclassified report and classified appendix, is presented in fulfillment of these requirements and sets forth our principal findings and recommendations concerning the matters that were the subject of our review. The principal report is confidential, but contains no classified information based on thorough, coordinated reviews of the information contained therein by the appropriate authorities within the Federal Bureau of Investigation, the Central Intelligence Agency, and the National Security Agency. The classified appendix likewise has been coordinated with those same agencies for classification purposes. A side note by the reader: I am not going to be reading the references that will be in a PDF file that I'm reading from. I'm just going to read the meat of it, everything, but I don't want to get into all the references because it's going to be really complicated to understand. Okay, continuing. We note that the classified appendix contains some information that is derived from Foreign Intelligence Surveillance Act, FISA authorities. Accordingly, to the extent the Department determines that it is appropriate to share information contained in the classified appendix with the congressional or other government entities outside of the Department, steps will need to be taken in accordance with that act and any relevant orders that have been issued by the Foreign Intelligence Surveillance Court. Page 2. Finally, we want to thank you and your office for permitting our inquiry to proceed independently and without interference, as you assured the members of the Senate Judiciary Committee would be the case during your confirmation hearings and to become Attorney General of the United States. Page 3. Report on matters related to intelligence activities and investigations arising out of the 2016 presidential campaigns. Special Counsel John H. Durham, submitted pursuant to 28 C.F.R. 600.8c, Washington, D.C., May 12, 2023. The next page is several pages of the table of contents. I will be skipping all of those. I'm skipping down to the introduction, and we are starting over on page 1. Introduction. This report is submitted to the Attorney General pursuant to 28 C.F.R. 608c, which states that, at the conclusion of the Special Counsel's work, he shall provide the Attorney General a confidential report explaining the prosecution or declination decisions reached by the Special Counsel. In addition to the confidential report required by Section 608c, the Attorney General has directed that the Special Counsel, to the maximum extent possible and consistent with the law and the policies and practices of the Department of Justice, shall submit to the Attorney General a final report and such interim reports as he deems appropriate in the form that will permit public dissemination. This report is in fulfillment of these requirements and sets forth our principal findings and recommendations concerning the matters that were subject of our review. Section 1 briefly describes the scope of our investigation, and Section 2 is an executive summary of this report. Section 3 describes the laws and Department of Federal Bureau of Investigation, FBI, policies that applied to or were addressed in our investigation. Section 4 summarizes the facts and evidence that we found and describes our prosecution and declination decisions. In Section 5, we provide some observations on issues pertinent to our areas of inquiry. Section 1. The Special Counsel's investigation. On March 2019, Special Counsel Robert S. Mueller III concluded his investigation into into the Russian government's efforts to interfere in the 2016 presidential election, including any links or coordination between the Russian government and individuals associated with the Trump campaign. That investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities. Following Special Counsel Mueller's report on May 13, 2019, Attorney General Barr directed United States Attorney John Durham to conduct a preliminary review into certain matters related to the 2016 presidential election campaigns, and that review subsequently developed into a criminal investigation. On February 6, 2020, the Attorney General appointed Mr. Durham as Special Attorney to the Attorney General pursuant to 28 U.S.C. 515. On October 19, 2020, the Attorney General determined that, in light of the extraordinary circumstances relating to these matters, the public interest warrants Mr. Durham continuing this investigation pursuant to the powers and independence afforded by the Special Counsel regulations, relying on the authority vested in the Attorney General, including, and it gives a bunch of numbers to reference. Sorry, I'm just trying not to bore the hell out of everybody. Attorney General ordered, I believe on page 3 now. Attorney General ordered the appointment of the Special Counsel in order to discharge the Attorney General's responsibility to provide supervision and management of the Department of Justice and to ensure a full and thorough investigation of these matters. The order stated, the Special Counsel is authorized to investigate whether any federal official, employee, or any other person or entity violated the law in connection with the intelligence, counterintelligence, or law enforcement activities directed at the 2016 presidential campaigns, individuals associated with those campaigns, and individuals associated with the administration of President Donald J. Trump, including but not limited to Crossfire Hurricane and the investigation of the Special Counsel, an investigation of Special Counsel Robert S. Mueller III. If the Special Counsel believes it is necessary and appropriate, the order further provided the Special Counsel is authorized to prosecute federal crimes arising from his investigation of these matters. The order also provided that 28 C.F.R. 604 to 610 are applicable to the Special Counsel. We have not interpreted the order as directing us to investigate the Department's handling of matters associated with the investigation of former Secretary of State Hillary Clinton's use of a private email server. For a review of those matters, see Office of the Inspector General, U.S. Department of Justice, a review of various actions by the Federal Bureau of Investigation and Department of Justice in advance of the 2016 election, June 2018. We also have not interpreted the order as directing us to consider the handling of the investigation into President Trump opened by the FBI on May 16, 2017. See FBI EC Firm Counterintelligence, Foreign Agents Registration Act, Russia Sensitive Investigative Matter, May 2016, 2017. The following day, the Deputy Attorney General appointed Special Counsel Mueller to investigate Russian interference with the 2016 presidential election and related matters. See Mueller report at pages 11-12, describing the authorities given to the Special Counsel Mueller. Finally, we have not interpreted the order as directing us to consider matters addressed by the former United States Attorney for the District of Utah or by former United States Attorney for the Eastern District of Missouri, other than those relating to Crossfire Hurricane or the FISA applications targeting Carter Page. For accounts of these matters in the news media, see Thomas Burr and Pamela Manson, U.S. Attorney for Utah, is investigating GOP-raised concerns about the FBI surveilling Trump aide and about Clinton's uranium ties. I'm going to skip a bunch of this. I just wanted to read part of that. That was some of that reference I wasn't going to read, but it seems relevant because that's what a lot of people want to know, is why some of this wasn't covered. On December 21, this is actually page 3. On December 21, 2020, the Attorney General delegated certain authority to use classified information to the Special Counsel. After the inauguration of President Biden, Attorney General Garland met with the Office of Special Counsel, OSC, or the Office. The Office very much appreciates the support consistent with his testimony during his confirmation hearings that the Attorney General has provided to our efforts and the Department's willingness to allow us to operate independently. The Special Counsel structured the investigation in view of his power of authority to exercise all investigative and prosecutorial functions of any United States attorney. Like a U.S. Attorney's Office, the Special Counsel's Office considered in the course of its investigation a range of classified and unclassified information available to the FBI and other government agencies. A substantial amount of information and evidence was immediately available to the office at the inception of the investigation as a result of numerous congressional investigations and Special Counsel Mueller's investigation. The examination by the Office of the Inspector General, OIG, and Crossfire Hurricane investigation, the Foreign Intelligence Surveillance Act, FISA, applications targeting Carter Page, and other matters provided additional evidence and information, as did an internal report prepared by the FBI's Inspection Division. The office reviewed the intelligence, counterintelligence, and law enforcement activities directed at the 2016 Trump campaign and individuals associated either with the campaign or with the Trump administration in its early stages. The office structured its work around evidence for possible use and prosecutions for federal crimes, assuming that one or more crimes were identified that warranted prosecution. The office exercised its judgment regarding what to investigate, but did not investigate every public report of an alleged violation of law in connection with the intelligence and law enforcement activities directed at the 2016 presidential campaigns. In addition to the special counsel, the office has been staffed by experienced FBI and Internal Revenue Service criminal investigation division agents, department attorneys and prosecutors, support personnel, and contractor employees. The office's investigation was broad and extensive. It included investigative work both domestically and overseas. It entailed obtaining large document productions from businesses, firms, government agencies, universities, political campaigns, internet service providers, telephone companies, and individuals. The office interviewed hundreds of individuals, many on multiple occasions. The office conducted the majority of interviews in classified settings. For some interviewees and their counsel security clearances needed to be obtained. The office conducted interviews in person and via video link, and the vast majority of the latter occurring after the COVID-19 pandemic-related closures began on March 2020. Although a substantial majority of the individuals voluntarily cooperated with the office, some only provided information under subpoena or grant of immunity. Some individuals who, in our view, had important and relevant information about the topics under investigation refused to be interviewed or otherwise cooperate with the office. As of April 2023, with 2 trials completed, the office has conducted more than 480 interviews, obtained and reviewed more than 1 million documents consisting of more than 6 million pages, served more than 190 subpoenas under the auspices of grand juries, executed 7 search warrants, obtained 5 orders for communications records under 18 U.S.C. 2703D, and made 1 request to a foreign government under a mutual legal assistance treaty. The office would like to express its appreciation to, among others, the FBI's Office of General Counsel, OGC, and Inspection Division, Litigation Technology Support Services Unit in the National Security Division, the e-Discovery Team in the Office of Chief Information Officer and the Justice Management Division, and JMD's Service Delivery Staff. The NSD and JMD entities created and maintain the databases and technology infrastructure needed to organize and review large amounts of data we obtained. The office would like to express its appreciation to the Department Office of Privacy and Civil Liberties for its guidance on appropriate information to include in the public report. Forgive me if I'm getting some of these pages wrong. Page 5. The office has concluded its investigation into whether any federal official, employee, or any other person or entity violated the law in connection with the intelligence, counterintelligence, or law enforcement activities directed by the 2016 presidential campaigns, individuals associated with those campaigns, and individuals associated with the administration of President Donald J. Trump. This report is a summary. It contains in the office's judgment that information necessary to account for the special counsel's prosecution and declination decisions and describe the investigation's main factual results. It then sets forth some additional observations. The office made its criminal charging decisions based solely on the facts and evidence developed in the investigation and without fear of or favor to any person. What is stated below in the Mueller report is equally true for investigation. This report describes actions and events that the special counsel's office found to be supported by the evidence collected in her investigation. In some instances, the report points to the absence of evidence or conflicts in the evidence about a particular fact or event. In these instances, when substantial, credible evidence enabled the office to reach a conclusion with confidence. The report states that the investigation established that certain actions or events occurred. A statement that the investigation did not establish particular facts does not mean there was no evidence of those facts. Conducting this investigation required us to consider U.S. criminal laws, the constitutional protections our system provides to individuals, and the high burden placed on the government to prove every element of crime beyond a reasonable doubt. Moreover, the law does not always make a person's bad judgment, even horribly bad judgment, standing alone, a crime. Nor does the law criminalize any unseemly or unethical conduct that political campaigns might undertake for tactical advantage. Absent a violation of a particular federal crime statute, finally, in almost all cases, the government is required to prove a person's actual criminal intent, not mere negligence or recklessness, before that person's fellow citizens can lawfully find him or her guilty of a crime. The office's adherence to these principal explanations in numerous instances why conduct deserving of censure or disciplinary action did not lead the office to seek criminal charges. There are also reasons why, in examining politically charged and high-profile issues such as these, the office must exercise and has exercised special care. First, juries can bring strongly held views to the courtroom in criminal trials involving political subject matters, and those views can, in turn, affect the likelihood of obtaining a conviction. Separate and apart from the strength of the actual evidence, and despite a court's best efforts to impanel a fair and impartial jury. Second, even when prosecutors believe they can obtain a conviction, there are some instances in which it may not be advisable to expend government time and resources on a criminal prosecution, particularly where it would create the appearance, even if unfounded, that the government is seeking to criminalize the behavior of political opponents or punish the activities of a specific political party or campaign. At the same time, prosecutors should not shy, page 6, away from pursuing justifiable cases solely due to the popularity of the defendant or the controversial nature of the government's case. The principles of federal prosecution provide the following pertinent guidance on this point, which inform the special counsel's charging and declination decisions. Where the law and the facts create a sound prosecutable case, the likelihood of an acquittal due to unpopularity of some aspects of the prosecution or because of the overwhelming popularity of the defendant or his/her cause is not a factor prohibiting prosecution. For example, in a civil rights case or a case involving an extremely popular political figure, it might be clear that the evidence of guilt viewed objectively by an unbiased fact finder would be sufficient to obtain and sustain a conviction. Yet the prosecutor might reasonably doubt, based on the circumstances, that the jury would convict. In such a case, despite his/her negative assessment of the likelihood of a guilty verdict, based on factors extraneous to an objective view of the law and the facts, the prosecutor may properly conclude it is necessary and appropriate to commence or recommend prosecution and allow the criminal process to operate in accordance with the principles set forth here. The decision of whether to bring criminal charges in any given matter, thus, is a complicated one that is neither entirely subjective nor mechanistic. If this report and the outcome of the special counsel's investigation leave some with the impression that injustices or misconduct have gone unaddressed, it is not because the office concluded that no such injustices or misconduct occurred. It is rather because not every injustice or transgression amounts to a criminal offense, and criminal prosecutors are tasked exclusively with investigating and prosecuting violations of U.S. criminal laws. And even where prosecutors believe a crime occurred based on all the facts and information they have gathered, it is their duty only to bring criminal charges when the evidence that the government reasonably believes is admissible in court proves the offense beyond a reasonable doubt. Both Attorneys General Barr and Garland have stated that one of their most important priorities is to ensure the proper functioning and administration of federal law by government agencies. Instead, the first goal of the department's current strategic plan is to uphold the rule of law. We will continue our work to ensure that the public views the department as objective, impartial, and insulated from political influence. The Justice Department's foundational norms, including the principled exercise of discretion, independence from improper influence, treating like cases alike, and an unwavering commitment to follow the facts and the law, reaffirming and, where necessary, strengthening the Justice Department policies, page 7, that are foundational to the rule of law, many of which were initially adopted in the aftermath of Watergate, is essential to this effort. In the aftermath of Crossfire Hurricane and the FISA surveillances of Page, the Department has adopted other important policies. We discuss them and possible additional changes in portions of the report that follow. Section 2, Executive Summary. The public record contains a substantial body of information relating to former President Trump's and the Trump Organization's relationships with Russian businesses, Russian business people, and Russian officials, as well as separate evidence of Russia's attempts to interfere in the 2016 presidential election. These and related subjects are well documented in the careful examinations undertaken by the Department, Office, and Inspector General of issues related to the FBI's Crossfire Hurricane investigation and its use of Foreign Intelligence Surveillance Act authorities. Former FBI Director Robert Mueller, as detailed in his report entitled Report on the Investigation into Russian Interference in the 2016 Presidential Election, issued in March 2019, and the Senate Select Committee on Intelligence entitled Russian Active Measures, Campaigns, and Interference in the 2016 U.S. Election. The scope of these earlier inquiries, the amount of important information gathered, and the contributions they have made to our understanding of Russian election interference efforts are a tribute to the diligent work and dedication of those charged with the responsibility of conducting them. A review and investigation, in turn, has focused on separate but related questions, including the following. Was there adequate predication for the FBI to open the Crossfire Hurricane investigation from its inception on July 31, 2016, as a full counterintelligence and foreign agents, page 8, Registration Act, FARA, F-A-R-A, investigation, given the requirements of the Attorney General's guidelines for FBI domestic operations and FBI policies relating to the use of the least intrusive investigative tools necessary? Was the opening of Crossfire Hurricane as a full investigation on July 31, 2016 consistent with how the FBI handled other intelligence it had received prior to July 31, 2016 concerning attempts by foreign interests to influence the Clinton and other campaigns? Similarly, did the FBI properly consider other highly significant intelligence it received at virtually the same time as that used to predicate Crossfire Hurricane, but which related not to the Trump campaign, but rather to a purported Clinton campaign plan to vilify Donald Trump by stirring up a scandal claiming interference by Russian security services, which might have shed light on some of the Russian information the FBI was receiving from third parties, including the Steele dossier, the Alpha Bank allegations, and confidential human resources reporting? If not, were any provable federal crimes committed in failing to do so? Was there evidence that the actions of any FBI personnel or third parties relating to the Crossfire Hurricane investigation violated any federal criminal statutes, including prohibiting against making false statements to federal officials? If so, was that evidence sufficient to prove guilty beyond a reasonable doubt? Was there evidence that the actions of the FBI or department personnel in providing false or incomplete information to the Foreign Intelligence Surveillance Court violated any federal criminal statutes? If so, was there evidence sufficient to prove guilt beyond a reasonable doubt? Our findings and conclusions regarding these and related questions are sobering. State of intelligence community information regarding Trump and Russia prior to the opening of Crossfire Hurricane. As set forth in greater detail in Section 4A3B, before the initial receipt by FBI headquarters of information from Australia on July 28, 2016, concerning comments reportedly made in a tavern on May 6, 2016 by George Papadopoulos, an unpaid foreign policy advisor to the Trump campaign, the government possessed no verified intelligence reflecting that Trump or the Trump campaign was involved in a conspiracy or a collaborative relationship with the officials of the Russian government. Indeed, based on the evidence gathered in the multiple, exhaustive, and costly federal investigations of these matters, including the instant investigation, neither U.S. law enforcement nor the intelligence community appeared to have possessed any actual evidence of collusion in their holdings at the commitments of the Crossfire Hurricane investigation. Page 9. The opening of Crossfire Hurricane. As set forth in greater detail in Section 4, The record in this matter reflects that upon receipt of unevaluated intelligence information from Australia, the FBI swiftly opened the Crossfire Hurricane investigation. In particular, at the direction of Deputy Director Andrew McCabe, Deputy Assistant Director for Counterintelligence Peter Strzok opened Crossfire Hurricane immediately. Strzok, at a minimum, had pronounced hostile feelings towards Trump. The matter was opened as a full investigation without ever having spoken to the persons who provided the information. Further, the FBI did so without any significant review of its own intelligence databases, collection and examination of any relevant intelligence from other U.S. intelligence entities, interviews of witnesses essential to understand the raw information it had received, or using any of the standard analytical tools typically employed by the FBI in evaluating raw intelligence. Had it done so, again, as set out in sections 4A3B and C, the FBI would have learned that their own experienced Russia analysts had no information about Trump being involved with Russian leadership officials, nor were others in sensitive positions at the CIA, the NSA, and the Department of State aware of such evidence concerning the subject. In addition, FBI records prepared by Strzok in February and March 2017 show that at the time of the opening of the Crossfire Hurricane, the FBI had no information in its holdings indicating that at any time during the campaign, anyone in the Trump campaign had been in contact with any Russian intelligence officials. The speed and manner in which the FBI opened and investigated the Crossfire Hurricane during the presidential election season, based on raw, unanalyzed, and uncorroborated intelligence, also reflected a noticeable departure from how it approached prior matters involving possible attempted foreign election interference plans aimed at the Clinton campaign. As described in Section 4B, in the 18 months leading up to the 2016 election, the FBI was required to deal with a number of proposed investigations that had the potential of affecting the election. In each of those instances, the FBI moved with considerable caution. In one such matter discussed in Section 4B1, FBI headquarters and department officials required defensive briefings to be provided to Clinton and other officials or candidates who appeared to be the targets of foreign interference. In another, the FBI elected to end an investigation after one of its longtime and valuable CHSs went beyond, that's a CHS, confidential, went beyond what was authorized and made an improper, page 10, apologies, I'm going to reread that sentence. In another, the FBI elected to end an investigation after one of its longtime and valuable CHSs went beyond what was authorized and made an improper, page 10, and possibly illegal financial contribution to the Clinton campaign on behalf of a foreign entity as a precursor to a much larger donation being contemplated. And in a third, the Clinton Foundation matter, both senior FBI and department officials placed restrictions on how those matters were to be handled, such that essentially no investigative activities occurred for months leading up to the election. These examples are also markedly different from the FBI's actions with respect to other highly significant intelligence it received from a trusted foreign source, pointing to a Clinton campaign plan to vilify Trump by tying him to Vladimir Putin so as to divert attention from her own concerns relating to her use of a private email server. Unlike the FBI's opening of a full investigation of unknown members of the Trump campaign based on raw, uncorroborated information in this separate matter involving a purported Clinton campaign plan, the FBI never opened any type of inquiry, issued any taskings, employed any analytical personnel, or produced any analytical products in connection with the information. This lack of action was despite the fact that the significance of the Clinton plan intelligence was such as to have prompted the director of the CIA to brief... rereading that. In another, the FBI elected to end an investigation after one of its longtime and valuable CHSs went beyond what was authorized and made an improper and possibly illegal financial contribution to the Clinton campaign on behalf of a foreign entity as a precursor to much larger donation being contemplated. And in a third, the Clinton Foundation matter, both senior FBI and department officials placed restrictions on how those matters were to be handled, such that essentially no investigative activities occurred for months leading up to the election. These examples are also markedly different from the FBI's actions with respect to other highly significant intelligence it received from a trusted foreign source pointing to a Clinton campaign plan to vilify Trump as tying him to Vladimir Putin so as to divert attention from her own concerns relating to her use of a private email server. Unlike the FBI's opening of a full investigation of unknown members of the Trump campaign based on raw, uncorroborated information in the separate matter involving a purported Clinton campaign plan, the FBI never opened any type of inquiry, issued any taskings, employed any analytical personnel, or produced any analytical products in connection with the information. This lack of action was despite the fact that the significance of the Clinton plan intelligence was such as to have prompted the director of the CIA to brief the president, vice president, attorney general, director of FBI, and other senior government officials about its content within days of its receipt. It was also of enough importance for the CIA to send a formal written referral memorandum to Director Comey and the Deputy Assistant Director of the FBI's Counterintelligence Division, Peter Strzok. For those considerations and actions, the investigative referral provided examples of information the Crossfire Hurricane Fusion Cell had gleaned to date.